Hello and welcome to the latest podcast for Legal Eagle Trading Limited. My name is Colin Beaumont. Today's podcast, you do not have to say anything. Adverse inferences at trial. Nor, we could put in brackets, you don't have to provide those wretched samples. Nor do you need to undergo an X-ray or an ultrasound scan. But there may be adverse inferences at trial if you don't. Morning, Clive.
Hello, Colin. You do not have to say anything. It's quite an interesting title for a podcast, isn't it? The listeners, of course, don't have to say anything, but we're going to have to say quite a lot over the next 45 minutes to an hour or so, aren't we? And all the listeners need to do is to tune in and listen and hopefully learn a little bit.
Yes, and read the show notes. Presumably you've done some show notes, Clive.
Of course, Colin, I've done my homework. Yep. Cases, excellent. Legislation, all the rest of it. Let's just give a quick overview. You've already touched on a few bits, Colin. We're gonna work our way through chronologically, aren't we, in terms of inferences at trial? You know, what happens at the police station, what happens when you get to court, and then a few other bits really that have been added on over the years. It's evolved in a piecemeal basis. We all know that all of this kicked in with the Criminal Justice Public Order Act 1994. But we've had other bits like defence statements and witness notices, and we're going to have a little bit of a look at that. Colin, some years ago when I was still in practice, I went to a really interesting lecture at the Old Bailey, organised by the Criminal Bar Association, and it was entitled Defendants in Criminal Trials, Active Participants or Passive Spectators. And it charted the history of the law in this area in the sense that, pre-94, you could sit there and say nothing in interview. You could get to court and you could say nothing at the pre-trial hearings, and you could get to trial and you could say nothing too. I think you'd agree with me, Colin, that strict and absolute right to silence has been eroded somewhat over the last 40 or so years, and we keep getting little incremental bits and pieces, don't we?
We do, yes. I mean, I always say to students, look, you can say nothing in the interview if you want to. I mean, you can be mute if you want to. And some of my clients were mute in the interview upon my advice, greatly to the annoyance of the interviewing police officers. However, in 1994, Criminal Justice and Public Order Act 1994, inroads were made into the right to silence, whereby the legislation now, of course, is that, yes, of course, you don't have to say anything, but it may harm your defence if you do not mention when questioned something upon which you later rely at trial. So there are consequences now, are they not, for remaining silent in your interview.
You say inroads, Colin. It was more like a 4-lane motorway, wasn't it? Failure to mention when questioned, failure to give evidence, failure to account for objects, substances and marks, and failure to account for your presence at the scene. So 4-lane motorway, I think, is a nice way of remembering it, isn't
it? I speak to lawyers all the time, and they say, Colin, it doesn't seem to be that much of an issue in a magistrate's court trial. Well, if that's what they say, but I think you and I both know at the Crown Court, if it can take on some significance.
I think it's enough to tip the balance in the right cases, Colin. That's the point.
It is. And I said to my wife, who's not a lawyer, I remember once saying to her, look, if you were to sit on a jury and you were told or learned during the course of the trial that he or she had had a no comment interview or said nothing to the police whatsoever, how do you think, what would be your general response? And she said, well, I think that he or she had something to hide. There you have it, the opinion of a non-lawyer who might one day sit on a jury.
Good. Well, shall we kick off then with the police station, Colin? This is very much your domain, isn't it? I went to the police station, a very, very long time ago doing work experience when I was still at university. And I have to say, I found it absolutely fascinating. It is such a hostile environment to operate in. And I say this as counsel, as I say, someone who never really went there in a professional capacity, as an observer on a couple of occasions. But this is very much your domain. So over to you on this bit, Colin.
Okay. I'd agree with you. The police station at times can be can be a challenging place, for a defence lawyer, particularly if the police officers are not being very forthcoming, and particularly if you've got a difficult client, and it's 2:00 in the morning, and you dearly wish to phone a friend, but it's 2:00 in the morning. Obviously, we have to have a chat with the client, don't we? Prior to the interview, we say, look, let's just talk about the caution, shall we? You don't have to say anything to the police. You really don't have to say anything. You can be mute if you want to, but you will be cautioned in the sense of if you do not mention facts upon which you would later seek to rely at trial, then, of course, adverse inferences may be drawn. Obviously, we try not to use the word adverse or influence. I think I put it on the basis that, look, if you don't mention now things you later rely on, the court, as it were, may find your version, your defence, less believable. The court will be entitled to say, well, if this is the truth, why didn't he or she say it to the police on the occasion when they've interviewed? Of course, a client might decide to deal with it in another way by having a no-comment interview, but the lawyer, solicitor, reading out a prepared statement containing the salient facts. We know that the Court of Appeal said in the 2003 decision of Regina and Knight that there was no requirement upon a suspect to actually answer the questions. However, there was a requirement upon the suspect to lay down the facts as known to him or her at the time of the interview, the salient facts of their defence, at the risk of adverse inferences being drawn at trial. And of course, a person might do that by the lawyer reading out a prepared statement during the interview, or perhaps possibly even at charge. That really covers, doesn't it, Clive, the standard adverse inference section 34 of the Criminal Justice and Public Order Act of 1994. No doubt you'll deal with section 35, someone not testifying at trial.
Can I just say a little bit about section 34? You're right to mention Knight. You're right to mention Knight, and I really like the case of Knight. I have to say, I had a firm of solicitors that used to instruct me a lot, and they were big fans of it too. And many of their solicitors would provide pre-prepared statements, and I liked them. I think they worked in the right case, and their solicitors felt confident with them. Two things, really. Knight says this, doesn't it? That you're supposed to give, an indication of what your sentence is. Your duty at interview is not to subject yourself to cross-examination by the police. That's your duty at trial, effectively, isn't it? You don't need to give every last detail of your defence. But as long as you give it in, not even broad brush terms, but, if you give your account and say, look, I was acting in self-defence and this is what happened, and give a little bit of detail, that should be enough. But there's a really nice phrase in Knight as well, that the submission of a pre-prepared statement is not an inevitable antidote to the drawing of an inference. And I really like that phrase. It's not an inevitable antidote. It is a balance. I think it is something that I know not all solicitors feel comfortable doing, but I certainly think those who do use them and become comfortable and competent and able to use them certainly see the benefit of them. And you tend to see them quite often in murders too. And the reason that happens, as you know, Colin, is what tends to happen in murder trials, or in the investigation stage, at least before we get to charge and trial, is that the police will use what's known as a phased disclosure approach. So they will tell you a little bit and they will ask for your response and answers. And then they'll tell you a little bit more and they'll ask for your response and answers. And of course, they famously use what's referred to as the bedtime story. So as you know, Colin, there are certain times when the police are not allowed to question you because you have to have some rest and refreshments and all of that. But what they like to do is, before you start that, is they give you something to think about and something to chew over. So, for example, they'll say, no, just come to the end of this interview. We'd like you to explain in the next interview, when we speak in the morning, how your DNA came to be on the knife, which we now know to be the murder weapon. Just have a think on that, will you? And see how you sleep at night. So that's commonly known as the bedtime story, isn't it, Colin? Something to ruffle the suspect's feathers and to try and disrupt their sleep and to try and get them to say something inconsistent or differently or wildly inaccurate or untrue in the morning, which can then be held against them at trial. So it's a bit of a tactic, isn't it? I like the case of Knight for that reason, but just a couple of points and observations on that. And before we move away, this is a case that we talked about a few years ago now, Colin, the case of Harewood and Raymond. And this is really the latest, and I would say the most important authority we've had on adverse inferences in the last 5 years or so. This, as you know, Colin, this was a murder trial at the Old Bailey. It's in front of a very, very able and bright judge called Wendy Joseph, who's now retired. Quite often here on Radio 4. She's wonderful. I could listen to her all day. She's written a couple of really good books as well on the law. I've read both of them, actually. One that's called Unlawful Killing, so recommend that. No commission here, so it's just a great book and well worth the read. Anyway, she was hearing a murder trial at the Old Bailey. I think it was one of her last trials, and the defendants were convicted, and it went on appeal. One of the issues on appeal in relation to the adverse inferences was effectively the defendant said, well, you can't draw an inference because the police never asked us that. Okay, and it was a murder on a landing. It was a cannabis deal gone wrong, and some young men, I think, went to buy some cannabis, and they decided to swindle the suppliers of the drugs by taking them on counterfeit currency and buying the drugs with counterfeit currency, so that they got double effectively. They didn't have to pay, and of course they then got the drugs. Unfortunately for them, during the drug deal, they got rumbled, and so a fight ensued, and knives were drawn, etc., and somebody sadly died. Harewood and Raymond actually handed themselves in at the police station, I think, from memory as well, because they knew that they were wanted by this time. And anyway, one of the grounds of appeal in relation to an adverse inference, because as we know, Section 34 says if you fail to mention when questioned something which you later rely on in court. And the point raised very broadly was whether or not the police had to ask a specific question. And therefore, if they didn't ask you, did you buy the drugs with counterfeit currency, and you didn't mention that we bought the drugs with counterfeit currency, does that mean that the jury can't draw an inference? And the Court of Appeal said no. They said in all of this, what's really important is context. So, for example, if you've been questioned about a murder, quite a serious incident, and the interview only lasted 2 minutes, what would it be reasonable for you to mention in those 2 minutes? Okay, and the answer is not everything. Okay, you're inevitably going to miss something out. However, in a murder investigation such as that, there were a number of interviews. They took place over several hours, and there was, felt the Court of Appeal and certainly the trial judge as well, ample opportunity for the defendants to put forward their account. Now, you can read the case of Harewood and Raymond, and there are a number of matters that the Crown drew to the trial judge's attention and said, we would like an inference in relation to this. The obvious one and the easy one to give you, because it fits the very brief facts of the case, is the fact that one of the defendants, I think it was the second one, Raymond from memory, I may be wrong, did not mention at the police station stage that they brought drugs with counterfeit currency. Now, I don't know about you, Colin, but it might be said by prosecution counsel that the purchase of drugs with counterfeit currency was the catalyst for the violence that ensued. Yeah. And you might think that was quite a significant and important matter, which was not mentioned.
I agree.
So, as I say, Harewood and Raymond, it's a really good read, and I think the word context is really important because, as I say, it may be a brief, we've mentioned magistrates' court trials, haven't we? It may be that it's a brief, relatively straightforward and simple matter, and the defendant may say, well, you never asked me about that, and I was only interviewed for 3 minutes, and the court might say, well, yeah, that's reasonable, actually. You shouldn't be expected to have mentioned it during such a brief interview in relation to what was a relatively simple and straightforward matter. But in other situations, murder, several hours of interviews, something which is arguably the catalyst for the violence, I think the court is going to find that it was reasonable for you to have mentioned it, and indeed it was unreasonable for you not to have mentioned it. But I think the really important point, because I think some lawyers have probably been saying this for some time, is that the police don't have to ask you a specific question. So the responsibility, the duty, it's incumbent upon the suspect, as they then are, to put forward their account simply, rather than playing sort of a game of chess. Well, you didn't ask me it, so I didn't answer. We don't have to ask you it. If you think it's important and it's relevant and it's going to be substantial, something substantial upon which you rely at trial, then the duty is on you to come forward with it, not for us to ask you the question.
Yes, I agree. And of course, this is something which people who perhaps aren't as experienced as others are troubled by. There is no duty upon the client, as it were, to lay all his cards out at the first interview. Now, you mentioned a murder. Gosh, if it's something like a murder, using all of these sections available to them under PACE, they can have that client for 4 days and 4 nights, 96 hours. I always took the view that let's wait, shall we? Let's have an interview. Let's have a few interviews. Let's at least see if the police have got a prima facie case before we start disclosing any defense we may or may not have. I remember as a young man going to my, just leaving the office on my first murder case, and someone who was very experienced said, Colin, remember, it's a murder. Think very carefully before your client speaks on the first day.
Yeah.
And
it's a marathon, not a sprint, isn't it, Colin?
Absolutely. I left the office with that ringing in my ears. Yes, there might be a time during the next 4 days when my client might want to lay something down. But does he or she want to lay something down now? The police having told me, legal term here, Clive, diddly squat about why he's there.
Other advice, Colin, I'd heard given to a solicitor going to the police station on their first murder was, it's just a Section 18 with a body. That's a nice way to think about it, they said.
Oh, I remember once receiving a call from the duty solicitor call centre. This person was obviously a novice because she said, Mr. Beaumont, he's been arrested for burglary. She said, but don't worry, she said, it's only a suspicion.
Isn't it always? Isn't it always?
Now, you're mentioning Harewood and Raymond reminds me of the case of Green, in which the Court of Appeal said something very similar. What happened with Mr. Green was that they started the interview, they showed a recording, everybody in the interview could see the recording, and the officer said, well, I've cautioned you, is there anything you'd like to say about what we're watching? He said, yes, no comment. And the officer said, yeah, that's fine. I'm going to caution you again. Don't have to say anything, blah, 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 blah. Is there anything you'd like to say at this point? We can all see what's happening. We can all watch the video. And he said, yes, no comment. And the officer said, well, if you're going to continue in that vein, I don't think there's much point in continuing this particular interview. So it's a final opportunity. Does anybody want to say anything before I close this interview down? The client said, yeah, no comment. There was then an argument, I don't think really it had any merit. There was an argument at the Crown Court trials that adverse inferences ought not to be drawn because he hadn't been asked a specific question about a specific matter which he was going to rely upon as part of his defence at trial. Well, the Crown Court judge was having none of it, and the Court of Appeal were having none of it as well. So no. He was given every opportunity to lay down the salient facts of his defence. Here was a man who clearly didn't wish to do so. End of story. That's what they said. You know, I ask a question which my students can never answer. And it's a very simple question, really, but it's probably not an easy answer. And it's, what is it in law that enables a court or a jury to consider the drawing of an adverse inference? What is it? And the simple answer is, it's the fact that Parliament has legislated for the drawing of an adverse inference. So you have to know the sections in which Parliament has said, and if you don't mention this particular fact, then adverse inferences may be drawn. Okay? But not everything is as an adverse inference. It might be the client is asked, well, can we look at your bank account? No. Will you provide us with a sample of your handwriting? No. These are not adverse inference sections. However, the matter may well be dealt with during the currency of the trial, and then the court or jury will make of it what they will. That's what the Court of Appeal said in the very interesting case of Virginia and Smith. A relative, perhaps. Virginia and
Possibly,
Smith.
Colin. Very distant if it was.
Court of Appeal at 1985. Section 36, of course, one of the so-called special warning sections. I'm now going to give you a special warning. I'm going to ask you to account for this object, substance or mark that was found on you or found near you at the point of arrest. Remember, this requires an arrest for he or she failure to account in the interview for the object, substance or mark, the object, substance or mark found on them or near them at the point of their arrest. Not so, of course, with your ordinary adverse inferences under Section 34, which are as relevant for volunteers as they are for suspects under arrest. And what is Section 36 at the end of the day? It's almost an aid memoir for police officers, isn't it? Oh, don't forget to ask him about that object. Don't forget to ask him about that particular substance, about that particular mark. It's almost a trigger for the police officers to ask a question apropos of that particular item. Objects, substances or marks found upon the person upon arrest or found near the person upon arrest. Section 36. Section 37, very similar, is it not? A failure to account for your presence at or near the scene of the crime upon arrest.
Caught in the morning, 2 o'clock in the morning, in the vicinity of a burglary. What were you doing out and about at 2 o'clock in the morning, hey? But as you say, the special warning were two things there, Colin, you've mentioned. One, the fact that you have to be under arrest in order for Section 36 to 37 to bite. And I think not a lot of people know that. And second, as you say, it's imperative that what's known as a special warning is given. And what that special warning is of course, the defendant, the suspect as they are at the police station, is given the general warning about an adverse inference if you fail to mention something that's important. And what we're saying now is it's particularly important. We're giving you a special warning about these particular questions that we're going to be asking you. Okay, it's all important, but these ones are particularly important. And before I ask these questions, I'm going to give you a special warning because you might want to think twice about not answering these questions. And as you say, that's laid out in Code C, isn't it? The Codes of Practice, the special inference that is required for officers to give the suspect during that interview.
Only a bit daunting, can't it? I mean, it's a stressful thing being interviewed, and when an officer says, I'm now going to give you a special warning, as if, and if you don't answer this particular question, you really are in trouble at trial. I always used to say to clients, look, don't worry about the special warnings. Trust me, sunshine, you have nothing worth saying. Yeah? It'll be no comment, won't it, to every question they put to you. Yeah? Because in answering the questions apropos of the special warning, you'd be making admissions effectively, wouldn't you? I well remember Harewood Police Station one particular evening, 2 clients who burgled the chemists and were caught hiding nearby with items from the chemist shop, would you believe, stuffed in their pockets. And they said, well, what shall we say about being arrested close to the scene, Mr. Beaumont? Well, no doubt you say nothing, because you'd just burgled the chemists, hadn't you? Oh, what should we say about all the things that were found in our pockets? Well, nothing. Why? Well, because they were items taken from the chemist that you'd burgled. Yeah. You've nothing worth saying, have you? Have you got a defence? No. Exactly. No comment.
I had a case like that, Colin, and do you know what his explanation was? He'd walked past the chemist after it had been broken into and these items were on the floor and he picked them up. I wasn't the burglar. I was merely handling stolen goods. The magistrates at Croydon swallowed it. There we are.
What about the doctrine of recent position?
Oh, well, exactly. I think that did get mentioned.
Dear. Can I just make an important point, which again, jurisprudentially is an important point, although many people giving advice at the police station have never fully taken it on board, and it's this. Parliament has said that in certain instances, adverse inferences may be considered by a court or may be considered by a jury. Now, why? Well, I'll tell you why. Because if you think about it, in relation to the state prosecuting you, if they can't get the actual evidence, an adverse inference is a fallback position. That's what they're left with if they can't get the piece of real evidence. As if they can't make you talk during the interview, but if you don't, adverse inferences may be drawn. They can't make you provide intimate samples, but if you don't, adverse inferences may be drawn. Which is why, of course, there can never be any adverse inferences where the police could take that evidence by force if necessary. There can be no adverse inferences from your failure to provide non-intimate samples. Why? Because the police can jolly well hold you down and take non-intimate samples by force if necessary. If they can get the evidence, they don't need an adverse inference. Adverse inference is the fallback position where the state cannot get the evidence.
This podcast is recorded on behalf of Legal Eagle Training. You can find us at legal-eagle-training.com.
Legal Eagle Training has nearly 100 one-hour recordings already on the website, and most of which come complete with notes. We've been doing these now since June 2020 on topics as diverse as
the Magistrates Court, including the Youth Court,
life at the police station,
road traffic,
advocacy, Magistrates Court advocacy, Crown Court advocacy,
criminal law updates, including case law and the latest legislation,
and the subject we both know most dear to your hearts, the billing of criminal legal aid.
The website is constantly being updated with new courses on the latest topics. We add 2 further presentations on the website per month. Each presentation lasts an hour and comes with a full set of notes. Do visit the website, as there's going to be something there that appeals to you as someone involved in criminal law.
Right, back to the episode.
So we've talked about Section 34, talked about 36 and 37. Let's come back to Section 35 in a bit, Colin. That's in relation to adverse inferences and failure to give evidence. Why don't you talk to us a little bit more then about the police station? What's an intimate sample? What's a non-intimate sample? And how does all this play out in practice in terms of what types of cases, like x-raying someone's stomach, for example? Why are we going to be doing that?
Well, let's deal with the intimate samples first of all. It will not be uncommon, of course, for a request to be made by the police that your client provides full intimate samples if he or she has been arrested in a rape. And of course, it's a very recent rape whereby samples have been taken from the complainant in the case, and they will want him to provide intimate samples like pubic hair combings, like penile swabs. And again, I have to remind students of the obvious, namely that when they're taking those intimate samples from him, if he consents, because intimate samples require his written consent, they're not looking for his DNA. Gosh, they can get his DNA quite easily if they want to by holding him down and plucking hair from his head. They're looking for the complainant's DNA on him. That's what they're looking for in those penile swabs. Might it be appropriate for him to provide those samples? Well, it might be, particularly so if he's going to say, well, as far as I'm concerned, sexual intercourse took place and I thought it was mutually consensual. I had no idea that there was going to be an allegation of rape. You could almost say, couldn't you, in those circumstances, well, if you're going to say that in the interview, there's no need for you to provide the intimate samples because evidentially the need for samples falls away if you're going to say that intercourse took place. Having said that, it was always my advice to a client, provide him anyway. It's nice for the lawyers to be able to say at trial, he complied with every request. He answered all of their questions in the interview. If you want to know about the list of intimate samples and non-intimate samples, well, of course, the list is contained in Section 65 of PACE. Section 65. It's mostly, isn't it, sexual matters, particularly rape, where they'll want a full set of intimate samples. But it might be a burglary where blood has been left at the scene and they therefore want a sample of blood, which again is an intimate sample within Section 65. And of course, it might be that the police officer says, well, okay, fair enough. If he or she won't provide intimate samples and that the officer's thinking this, let me think of other samples which I may take by force if necessary, which will put him in that particular flat, which will link him with that particular complainant. And what comes to my mind immediately? Hair, because we're shedding hair all the time. that might put him in her flat. Fingernail scrapings, who knows, we might find her DNA under his fingernails, or perhaps simple swabs of the hand or whatever. These are all non-intimate samples that the police can take using reasonable course if necessary, where a person fails or refuses to give their consent to the taking of intimate samples.
Good. So that's intimate samples and non-intimate samples. Talk to us about X-rays and ultrasounds, because I know that certainly in the neck of the woods where we used to practice, we used to get lots of people coming in on aeroplanes and things, didn't we? Who sometimes from countries like Jamaica. The JM001 flight into Heathrow was always a popular one with customs, and they would swallow things, wouldn't they, Colin, and be required to be held in police stations for several days until they passed these packages. And had to be X-rayed. And of course, highly, highly dangerous, because you only need one of them to split, and that's it. Game over, isn't it?
I know. I used to do the Heathrow police station, and we'd get the stuffers and the swallowers in.
The swallowers, as we called them, yeah.
Yeah, the stuffers and the swallowers. And if they'd got packages within them. I know that adverse inferences could be drawn because they don't have to agree to an X-ray. They don't have to agree to an ultrasound. But it was always my advice to them that, they really now ought to cooperate, because, as you say, gosh, if one of those packages burst, there was a chance they could die.
Do it for your health, if nothing else.
Yeah.
Tragic, sad cases, weren't they?
They were tragic, sad cases, absolutely. It's very rare to be advising that sort of client. It's far more likely that you're advising a client in a sexual matter about intimate samples.
But it's one of those, isn't it? Depending where you practice, this thing they can come relatively common. Equally, for some people, I'm sure they could go a whole career without ever having come across it, mightn't they? Depending where you practice. So,
yeah.
There we go.
Yeah.
Good. Right. So we've got through the police station, Colin. We've got through intimate samples, non-intimate samples, X-rays and ultrasounds. We've talked about failure to mention when questioned, something which you later rely on in court. And then we've talked about objects, substances and marks. And we've talked about your presence at the scene. The one major area we haven't talked about yet is Section 35 and your failure to give evidence. I have to say, certainly from my perspective as counsel, this didn't often happen. Well, three things really. One, if my client didn't give evidence, it was usually on advice from me. And I think in an 11-year career practice at the bar, I advised probably a handful of clients not to give evidence. In one memorable case in Kingston, 4 young men arrested in a car with drugs under the driver's seat. My client was the driver, actually. Interestingly, and quite clever, the prosecution put the front seat passenger first on the indictment. And anyway, I said to my client on the first day, I said, I don't think you should give evidence. Oh, I'll be fine, he says. Anyway, defendant 1 gets in the witness box, gives evidence. He was awful. Judge says to me, very, very experienced judge, says, Mr. Smith, he said, would you like a moment with your client before deciding whether to call him to go? Yes, please, Your Honour. Walked out into the conference room. My client said to me, he was awful. I said, I know. I said, sign here. I'd already drafted the endorsement, and I'll talk about that in a moment. He didn't give evidence. Defendant number 3, would you be giving evidence? No. Defendant 4, giving evidence? No. Prosecution, closing speeches. All happened in 10 minutes. It was brilliant. Jury went out, Colin. They came back and they acquitted defendants 2, 3 and 4. The one who gave evidence, they went out for another hour and made him sweat, and eventually came back and they acquitted them all. So they couldn't say who the drugs were. But yeah, very, very amusing case. But one of the few cases where I advised my client, because he'd said everything in interview. In fairness, he'd given a really full account in interview, and the police had done nothing to check what he'd said in interview. I said, you've got nothing more to add. You've got nothing more to add. It's only going to get more difficult if you give evidence. And of course, he saw that when defendant 1 gave evidence. Other situation where I had a client not give evidence, unhelpfully, was in the youth court, and my client's dad turned up, who, let's just say at that stage, I think he'd probably been involved in more criminal trials than I had, and said he's not giving evidence. So that was very unhelpful. But yeah, I don't think I ever had a client decide on their own that they weren't going to give evidence. I think I had a youth who didn't want to give evidence. He said he was just too nervous. And he was 13, no previous convictions in the youth court. I said to the prosecutor, he's not going to give evidence, he's just too nervous. He said, don't worry. He said, I'm not asking for an inference. He said, if I need an inference to get a 13-year-old with no previous convictions down, he said, I shouldn't be prosecuting this. But yeah, proper prosecutor, Colin. As you know, the best prosecutors always killed you with kindness. So yeah, that was really good, really fair. And of course, he was convicted because there was plenty of evidence. But yeah, so it's unusual. It's unusual for a defendant not to give evidence. Usually it will happen on advice, and it's a judgment call for you as the lawyer. If they're not going to give evidence, I've mentioned already that it's really important that you have an endorsement signed, because what will happen, as you know, Colin, there's a procedure in court, and in fact there's a practice direction which will be read to the defendant, usually by the district judge or the legal advisor in the magistrate's court, and certainly by the Crown Court judge at the Crown Court trial. And it says words along these lines. So the judge would say to me, Mr. Smith, have you advised your client that the stage in proceedings has now been reached at which he may give evidence should he so wish? Yes, I have, Your Honour. Mr. Smith, have you also advised your client that should he fail to give evidence or, having properly sworn, fail to continue to answer questions, that the court may draw such inferences appear proper from his silence? Yes, thank you, Your Honour, he's been so advised. And you stand there confidently and properly and resolutely and say to the judge, yes, he's been so advised. So hopefully the jury think, well, here's a lawyer who knows what he's doing, because you don't want to stand there and go, oh, no, I don't think I have, Your Honour. Can I have some time, please? Gosh, that would not do. That would not do. I'm joking. But and that endorsement will effectively say all of that my lawyers advised me that the stage in proceedings has now been reached, etc. And also, I'd always put at the end, usually, that I make this decision of my own free will and accord and in full knowledge of the consequences. In other words, the inferences will be drawn. So that's a very, well, not even a broad, but relatively specific wording in terms of what I put in that endorsement. And I always kept hold of that endorsement too. In terms of a defendant not giving evidence under Section 35, and I said, and I forget the exact wording of the language, Colin, because I think I only ever did it once, where I argued that my client should not be required to give evidence. And he had an IQ of 46. And I said that it was I think the words is it's undesirable for him to give evidence in the section.
Section 35, isn't it? Section 35, Criminal Justice and Public Order, 1994. Adverse inferences may be drawn against a person who fails or refuses to testify, or upon testifying, fails or refuses to answer certain questions.
In certain circumstances, it may be the court doesn't draw an inference where it's undesirable for the defendant to give evidence.
For a medical reason, I would have thought might be too poorly to give evidence.
Quite. I have to say, even when you and I started, Colin, this was very unusual for a defendant not to give evidence. There's very, very little case law from the Court of Appeal on it. And over recent years, it will become less and less relevant, because we know, don't we, that there are special measures such as intermediaries who are there to facilitate and aid defendants in giving evidence. So if it was rare when I started some 20 or so years ago now, it will be even rarer. And I can't remember reading a case on Section 35 and it being undesirable for a defendant to give evidence in the last 5 or 10 years, Colin. I don't know about you. It just doesn't come up, does it?
But I do remember a student once asking me a very clever question. It was at a conference, there were about 60 people in the room. And a voice at the back, and he put his hand up and said, I've got a question for you, Mr. Beaumont. I thought, oh, crikey, what's this? He said, you tell me, he said, is it possible for adverse inferences to be drawn if the client no comments the interview, but thereafter does not testify? Now that is a clever question. Because if you think about it, the question is really saying, can it be said that a defendant has sought to rely upon facts where he or she has not themselves testified? But fortunately, the Court of Appeal have already given it some thought. And we have the case of Chenya. Yeah, go on, Clive, if you want to mention Chenya, that was the answer to the student's question. Well, not a student, obviously a lawyer at a conference, but I thought it was a jolly clever question.
The point was, as you make, Colin, is that in terms of fail to mention when question something which you later rely on in court, you don't need to rely on it through the giving of direct evidence by yourself. You can do it, I would suggest, in one of maybe 2 or 3 ways. One, through cross-examination through your counsel, which is exactly what Mr. Chenya did. He advanced the positive case in cross-examination through his counsel without giving evidence. 2, you could call a witness to say, no, he was with me, or whatever it is. Or 3, I suppose you could put in documentary evidence as well, couldn't you? So there are various ways in which you can advance a positive defence without giving evidence yourself. And in effect, The point that Chenya really boiled down to, wasn't it, Colin, was whether or not a double inference could be drawn. So in other words, your failure to mention when questioned something which you later rely on in court, and then also your failure to give evidence under Section 35. Can you have a double inference? The Court of Appeal said, yes.
You can have a number of inferences. But the good point, of course, is that you cannot be convicted solely by adverse inferences. It requires evidence.
You could have 3, couldn't you? And it still wouldn't be enough.
Yeah. I used to say to clients in the police station, look, can we just forget this sapling, which is the adverse inference? Because I'm a bit concerned about this forest over here. Yeah. The evidence.
Namely, the evidence. And I do wonder, and I mean this genuinely, I do wonder what a double inference adds. I do wonder, in a longer running, which I think the case of Chenya was, I think it was a fraud and I think a building of a golf course or something from memory. And he was said to be the accountant. He was saying, no, nothing to do with me. I was just the consultant or advisor or something along those lines. And yes, I suppose in a longer running case, but I do wonder what a double or a triple inference really adds. Because ultimately what you're saying is, as the prosecutor, the defendant has failed to engage in the trial process.
Yeah.
We say the reason for his failure to engage in the trial process is because he has no valid account to put forward or one that would stand scrutiny. And effectively, the reason he's not saying anything is because he's guilty. He's not saying, and he's not giving you an account in an interview. He's not going to come and give evidence at trial. He's not going to account for those objects, substances or marks. He's not going to account for his presence at the scene. He's not going to do any of it. Why? Because we say he's guilty. So it all amounts to the same thing ultimately, doesn't it?
Hi, Bryn.
Another interesting point, I think probably maybe before we move on, Colin, is a case called Hackett. And I know I talked to you about this a few years ago, and it's perhaps something that those who practice in the lower courts, the magistrates' court, it's not something that you necessarily obviously come across for reasons that will become apparent. The case of Hackett is a really interesting case about directions to the jury, and so hence why it probably doesn't come up as much in the magistrates' court, although it could in a slightly different way. And Hackett said this, is should the trial judge give the jury both a lies and an inference direction? Now, let me explain that. Let me give you an example, Colin. Defendant or suspect is arrested for actual bodily harm, and he goes into the police station. It's a fight in a pub. And he says, I was not in the pub that night. I was at home watching Netflix and eating a pizza. I don't know what you're talking about. I was never there. Now, the police have got an eyewitness account, a bit of a grainy piece of CCTV as well, saying that it was Mr. Jones. He was there, and he was the one who attacked me and punched me and knocked me to the floor and caused these injuries, etc. And he says, not me, I wasn't there. Fine. So the police think, we've got enough evidence, we're going to charge you. They charge defendant in the next Crown Court trial. 6 weeks later, the Crown serve a notice of additional evidence. And the notice of additional evidence says this, that the suspect's blood was found on the trainer of the defendant. It's taken them some time. They seized his clothing when he was arrested, sent it away, and the suspect's blood was found on his trainers. The defendant then serves a defence statement at the plea and trial preparation hearing, and it says this, now, when I said in interview that I wasn't there and I was at home eating pizza and watching Netflix, what I meant to say was that I was there and I did get into a bit of a scuffle, but I was defending myself. Okay, so that's the scenario that faces the Crown Court judge. Now, the prosecution say this. They say, well, he's lied in interview. Okay, when he said, I was at home eating pizza, watching Netflix, that was a lie. And therefore, you should give a jury the direction on that, on lies, which effectively says, doesn't it? We know that just because someone's lied doesn't automatically mean they're guilty. It may mean they're guilty, but you have to be able to discount other possibilities first, such as they might have had a good reason to lie. For example, it might have been because they told their girlfriend they were at home that night and didn't want to get into trouble with her, whatever it is. Equally, the defendant has failed to mention when questioned something which he later relied on in court, because he put forward alibi in interview, didn't he? And actually his real defence was self-defence. So what he should have been saying at the police station was, I was there, I got into a scuffle and I was defending myself. But he didn't say that. So you could also give an adverse inference direction under Section 34. And in certain circumstances, judges have given both of those directions. And there was I have to say, at least my experience, others' experiences may be a little different, but a little known case of Hackett judgment was given back in 2011 that said, no. They said, you can't have both, or you shouldn't have both. It really should be one or the other, because effectively, these are two sides of the same coin, aren't they? All right. These are two sides of the same coin. And I have to say, whenever I raise this with trial judges, they often say to me, I wasn't aware of that, but Mr. Smith, you're quite right. Prosecutor, which one do you want? And I have to say, the judge would then say to me as well, which one do you want? And I'd always say the lies direction. And I'd always say the lies direction because it was quicker and shorter and I wanted to get it over with quickly. Now, another little tip I'll give you, Colin, Crown Court judges won't tell you this in open court, but they might tell you over a cup of coffee in chambers. Crown Court judges and recorders, they hate giving the adverse inference direction. It's so verbose and long and convoluted. If this, then that, and you must think this before you can do any of this. Oh, gosh, they hate giving that direction, Colin. And if you can give them an off-ramp, if you can give them a reason not to do it, they'll say, thank you very much, Mr. Smith, I'll give the lies direction. And a little secret, Colin, I never lost that argument. When I said to the judge, nudge, nudge, give the lies direction, whenever they heard from the prosecutor, said, no, I agree with Mr. Smith, I'm giving the lies direction. So there we go. But I have to say, I shouldn't leave people thinking that you should never give both. There is subsequent Court of Appeal authority from about 5 years ago that says in certain circumstances, it may be appropriate to give both the lies direction and an adverse inference direction. But I have to say, I think that's going to be the exception rather than the rule. And they're going to be on different things, okay? You're not going to give, so for example, in that situation where he's lied in interview, you're not going to give both. It's going to have to be a specific lie in interview and then a general adverse inference about other things maybe. But yeah, Hackett, really good case for prosecutors too. As I said earlier, a few moments ago, the best prosecutors always kill you with kindness. Your Honour, not asking for both. I'm just going to ask for a lies direction. Thank you very much. Thank you very much, Mr. Jones. That's very fair of you. Equally, defence counsel. Well, bit of a sledgehammer to crack a nut, isn't it? Two sides of the same coin. Let's just have one, shall we? But equally, in the magistrate's court, these are things you should be saying as a defence lawyer to district judges. Judge, you shouldn't be drawing both an inference and holding his lies against him. It's one or the other, surely. Okay, and these are things I think you can build real value with when it comes to trial, don't you, Colin, in terms of saying to judges, well, hang on, we've got all these things, but we should be discounting one of them. That's not fair.
Yes. Lovely. Couple of other points. Then in relation to adverse inferences, I think we ought to consider the position in relation to the failure on the part of the defendant to notify such details as are known to him.
Can I ask you one question before we move on to this?
Please do.
And this is a question that comes up every now and then. And you were the one who gave me the answer to this question, so I know you're going to know the answer. If I was prosecuting a case, could I say I'm not going to adduce the interview and evidence? It's a completely exculpatory account, entirely self-serving. I'm not going to put it in. What have the court said about that, Colin?
It was the Folkestone Justice's case in which the High Court said that, the interview should always go in. The more so where the suspect has put forward an account. Because, of course, if it doesn't go in, it means that the defence can't argue consistency. Look, he's saying the same thing at trial that he said to the police in the interview. So the interview should always go in. The more so, said the High Court, where it contains the suspect's account. And to be fair to the Crown Prosecution Service, by the time the matter got to the High Court, counsel for the Crown agreed that it was improper for the interview not to have been adduced at the magistrate's court stage. Folkestone Justices.
Yeah, Gonzalez and Folkestone's Justices. And they said that the interview takes on a special status, doesn't it? It's different to other ones because as a prosecutor, if he'd made admissions, you'd be relying on it, wouldn't you? But because he's made an exculpatory statement or, entirely self-serving comments, you're saying, I'm not going to put it in. Now my pupil master would kill me if he heard me saying this, Colin, but the prosecution are trying to have their cake and eat it. And the reason my pupil master would kill me, he said, well, why else do you want to have your cake? You're not going to sit there and look at it and wait for it to go mouldy. He said, why else wouldn't you want to have your cake and not eat it? So he hates that phrase. It always winds him up. So it makes me smile whenever anyone says that. But effectively, the High Court was saying, weren't they, the prosecution can't have their cake and eat it. They can't say, well, if it helps us, we'll put it in. If it hinders us, we won't.
Again, at a conference, a hand went up when I was discussing Folkestone, and the lawyer said, well, why couldn't the defendant himself adduce it as an exhibit? You can't. You can't adduce and exhibit a completely self-serving statement.
What about Section 120 of the Criminal Justice Act, Colin?
As being what? As being a consistent statement?
Previous consistent statement, yes. Prosecutor says to you in cross-examination, you're lying, you're just making this up. No, I'm not. I said this in an interview. Here it is. Rebut the suggestion of recent fabrication. That's got you thinking, hasn't it?
It has. But my response would have been to any prosecutor who, as it were, decided not to do it was, there's no property in a witness. Right. Okay. We'll call the officer and get him to exhibit it. But yes, it's a thought, isn't it? Section 120, consistent statements. It's a thought.
But it's just game playing, isn't it? Game playing by the prosecution. It shouldn't be happening. It shouldn't be happening.
No, it shouldn't be happening. You're quite right. So, meanwhile, back at defendants not notifying the prosecution. We know, don't we? This was an amendment. I think it's section 6C, large C of the CPIA. And of course, adverse inferences may be drawn in both the magistrate's court and the Crown Court in relation to the failure to notify the prosecution of witnesses. You might want to give this, Clive. We have that wonderful Crown Court case, don't we, of Kinyon. Do you remember? Crown Court judge at Reading?
Reading Crown Court.
Go on. Our stomping ground was Reading.
It was. I spent many a happy day at Reading. I suspect, and I may be being, I suspect what happened is, as usual, that often the recorders are lumbered with the appeals, if I can put it gently. And they're often, Fridays can be a busy day for a recorder. And I suspect this was a Friday. Master Tinney had been convicted, hadn't he, of driving whilst disqualified at Maidenhead Youth Court, and hadn't called any witnesses at his original trial. And was a little taken aback by his conviction, I think is fair to say. Appealed the matter to Reading Crown Court. And when he pitched up at Reading Crown Court for his appeal, turned up with 2 witnesses. And in fairness to the prosecution, they said, well, give us their names and dates of birth. We'll carry out a PNC check with them and we'll crack on. And the judge wasn't having any of it. And I dare say timing was an issue, that he was probably having a very busy day and thought, well, I've not got time to squeeze these in, and said effectively, no, you didn't give notice, so you can't call them, refused to allow them to be called. So anyway, Tinyon went off to the divisional court, and the divisional court said, no, they said wrong. Section 11 of the CPIA contains the sanction for failure to notify witnesses under Section 6C, and the sanction is not the refusal to allow them to be called. It is an adverse inference. Now, importantly, because I know you'll probably make this point if I don't, Colin, this only applies to civilian witnesses. Of course, if you turn up, as I think is it Rule 9 of the Criminal Procedure Rules, with an expert witness on the day, then I'm afraid the same thing will not happen. You must have served a report. The Crown must have had time to consider it and consider a response and all those sorts of things. So this only applies to civilian witnesses. Now, interestingly, if I can give a little bit of practical advice, Colin, I'll get your view and opinion on this too. Because if I was still in practice and going to the magistrate's court, we know what this looks like, don't we, Colin? We turn up on the first appearance and your client said there was a fight in a pub and, your client drinks there all the time. And he says, oh, yeah, Scouse John was there at the Dog and Duck. We play pool every week and he was there. He saw all this and he'll come and give evidence on my behalf. Right, okay. What's Scouse John's surname? I don't know. We just know him as Scouse John. All right. What's Scouse John's date of birth? I don't know. I just only ever meet him in the Dog and Duck. Well, where does Scouse John live? I don't know. I've never seen him at his house or walking around anywhere. I've only ever seen him in the Dog and Duck. Right, okay. So you and I both know, Colin, that we have very little information to give to the judge. Secondly, the chances of Scouse John turning up are slim to none. However, we've all been surprised. So my advice to you as a defence lawyer would be this. If you look at Section 6C, it says you must provide various details, name, address, date of birth, all those things, or such details as are known to you. And it may be at that first appearance, all you know is his name's Scouse, or his nickname is Scouse John, and he drinks at the Dog and Duck in Lambeth or wherever it may be. Put that on the form. Okay, I'm not joking. Put it on the form and also put a note saying that you will carry out inquiries through your client and you will make inquiries, and as soon as you are in possession of further and better particulars, district judge will like that phrase, further and better particulars, we will furnish you with them as soon as possible. Now, one of two things is going to happen. The most likely thing is that you'll turn up on the day of trial. John from the Dog and Duck has never been tracked down, and if he has, he's probably had a few pints, and he's definitely not coming to court to give your client evidence. And what happened at that first appearance is you gave the trial an hour and a half time estimate. Okay. John from the Dog and Duck hasn't turned up. You've not got a witness statement from him. Your client is not instructing you to apply for an adjournment to get him there. You can go into court and say, sorry, I've not got better information. We're not going to call him, not applying for an adjournment. Instead of an hour and a half trial, this trial's now going to take an hour. Okay. You are now favourite defence lawyer in the court building. Okay. Because you've just given the court back half an hour of time they never had. Oh, and by the way, if you don't call him and you said you were going to call him, there's no adverse inference. Okay, only an adverse inference where you don't give notice and then want to call them. No adverse inference where you do give notice and then don't call them. Option 2, John from the Dog and Duck turns up. You've told him it'll take an hour and a half. He gives evidence. Everyone's happy. Okay, so practically, Colin, that's my advice on a nutshell on Section 6C.
I agree. Clive, we're almost at the end of the hour, but let's just briefly mention, shall we, adverse inferences in relation to defence statements. Not applicable in the magistrate's court. Why? Well, because there is no duty upon you to provide a defence statement in the magistrate's court. The duty, of course, following a not guilty plea, is to make the prosecution aware of what the trial issues are, what the trial issues will be, which is a long, long way from a defence statement. Different at the Crown Court, as we know. It's Section 11, I believe, of the CPIA, where adverse inferences may be drawn if you fail to provide a defence statement, or on providing a defence statement, you depart from it.
Importantly, in the Crown Court, a case of Rochford from 2010 is an absolutely brilliant read. And I know, Colin, when you and I do some teaching, we have a top 10 cases for delegates to read, and Rochford's always in our top 10. Rochford says this, that as a lawyer in the Crown Court, you cannot advise your client not to serve a defence statement. Why? Because it's a statutory duty, and you cannot counsel or solicit or advise your client to breach a statutory duty. Now, if they don't want to serve one, matter for them, but you cannot advise them not to serve a defence statement. Rochford is important in other areas because the judge in that case was actually, as you know, Colin, contemplating holding defence counsel in contempt of court. He did hold the defendant in contempt of court for not serving better and fuller particulars on his defence statement and sentenced him to 28 days. And the Court of Appeal overturned that. But they go on to give some really good advice, don't they, Colin? Cases where you're going to put the Crown to proof. It talks about the fact that it's no longer really appropriate for you, in light of the criminal procedurals, to say the prosecution are put to strict proof. You must go further and say that the prosecution are put to strict proof. The defence advance no positive case. Now, I've got 40 seconds left, Colin, so I'm going to mention a final case on defence statements called Rorig from 2024, from last year. This is a case that I only read recently, but a really good read about the admissibility of defence statements. Here, the defendant in his defence statement had admitted stabbing the deceased. Now, the Crown had a bit of a problem because they had no evidence about who had stabbed.